Well, thanks, Chris, and welcome to Constitution Day. I agree with everything that Professor Schmidt said, except for the last. I'm not going to talk about what I think is the most important constitutional claims that have boiled up with respect to the Trump administration, and there have been many. I want to sort of tease out a puzzle that I've been going in my own mind. It's been clear so far that the Trump administration has taken its lumps in court. The travel ban was set back for a while. My prediction is it'll be rooted out in the Supreme Court, but Trump certainly lost a couple along the way. Just recently, in terms of the sanctuary cities of litigation that Chicago brought, as I predicted, Trump lost that as well. I think we'll continue to lose on that ground. There have been delays in EPA rule enforcement that he ordered that have been reversed by the courts as well. So as we see this wave, the good news is that we understand that some more prospective students are interested in law school because they see all these law victories against the Trump administration, which I think is a good hand. But I'm a little worried about a seepage effect. A seepage effect would be that are we now turning to a time when we think that every presidential action can be second-guessed in court. So I want to take it with you three issues that I think are traditionally, for good reason, been discretionary at the hands of the president, and suggest that even though we've seen these very important victories, and I think they're correct, in the travel ban case and sanctuary cities and so forth, I don't think we should continue to see this kind of court action against presidential actions because there is a reason for this kind of discretion. So looking at the first one is the pardon power. Pardon power is invested in the president, very little oversight historically, and indeed it's a check on the other branches. It's a check on punishments meted out in courts. It's a check on Congress for setting up what kind of punishments for particular crimes. Now it doesn't mean that the pardon power can't be abused. It can be, and it probably has been. I mean, President Clinton pardoned his half-brother as well as one of his largest campaign contributors, notoriously, and didn't even follow DOJ policy to cover justice policy when he did so. But now we've seen Trump enter the field by his controversial pardon of Sheriff Joe Arpaio of Arizona. And the pardon arose out of a contempt of court citation because Arpaio had not abided by the court's edict in terms of his policies, in terms of profiling Latinos within the jurisdiction. And yet some of my colleagues, not here but nationally, have suggested that we second-guess and challenge that pardon in court. I disagree with the pardon, I said that in print. But nonetheless, the question is, should courts review the substance of the policy? They shouldn't agree whether it's wise or not. That's not for courts to do. I go further and say they should say that there's a role, as some of our colleagues in the constitutional role have said, for courts to make sure that everybody in court make sure that they get their day in court and get their remedy. Because after all, that's exactly what a pardon does. It checks what the prosecutors and the legislature set in terms of punishment. And indeed, some people have said that we ought to second-guess the pardon in court because otherwise there may be due process violation in the future because other would-be Joe Arpaios will get the idea and go and decide to violate the rights of some group in the future as well because they may think they may get a pardon in the future from the president. So I think they receive those three different arguments of why we might open the courthouse doors to second-guess sort of discretionary action. I'll give you another one that may be even more controversial, which is the discharge of Comey. Right? Presidents have long been able to fire close lieutenants. Comey was head of the FBI for any reason at all. That's what presidential firing at will means. Right? So the arguments have been, well, wait a second, maybe the president fired Comey to obstruct justice, and therefore we should be able to second-guess that discharge as a way to make, and because it might be an obstruction of justice. I think the third might be seen in terms of policy statements as well, but I'll give you a third one instead, which is can you second-guess a presidential decision to veto or to sign something into law? Right? Presidents can do that. Let's say President Trump signs a trade law because he wants to help the Trump brain, so there could be an emoluments violation. Would you ever second-guess a veto or a decision on the basis of emoluments grounds? I don't think so. I think there's good reasons to keep that a black box and to keep sort of affinity with the Constitution that says some of these pardons, decisions to veto, or discharges of close lieutenants really should be off grounds for the judiciary, with a couple of exceptions. And I'll give you 2 exceptions now, which might be important for later, but then I might get my 5 minutes will be up. One exception is if the presidential action was sort of induced by fraud or has a fraudulent, or by a bribe, something else. And this has happened before. Governors have been bribed in terms of granting pardons, just like the Clinton pardon of Mark Rich may have been. So that's a situation where I think you can decide to step in as a court. Also, if there's a structural change in terms of separation of powers that is threatened. So I think that when the question of whether the president can use a pardon power to excuse a contempt of court and thereby rob the court of its ability to maintain its own house of order, that itself is pretty much of a shift of separation of powers. It should be amenable to challenge in courts. However, in this case, it already was about 75 years ago, and the courts held that the president can pardon even a contempt of court. But I do think that at least should be justiciable. So I think that in this combative world, where courts, I think, our lawyers are trying to challenge the egregiousness of many of Trump policies, that's a great thing, but I think we shouldn't lose sight of the fact that some kind of inherently discretionary presence in foreign policy, pardons, decisions whether to sign, legislation, etc., should be kept off limits except in very narrow circumstances. That's my puzzle for the day. Next.